All right, I think we're going to go ahead and get started. Welcome to the Law Enforcement Data webinar with the Data Practices Office. Thank you for joining us. If you've been watching our previous webinar series, you're familiar with the Data Practices Office by now. We are a resource on all things data practices and the open meeting law. Most of what we do is answer questions about both of these laws. We also provide training on different data practices and open meeting law topics. We're currently working on transitioning our in-person workshops to an online platform this fall, while also continuing these short webinars. We do record all of our webinars and post them on our YouTube page, and I'm going to share my screen with you to walk through how to access our webinar content. The link that I'll use to access our website is listed on this slide for you. Okay, so here is our Data Practices Office website. As you can see on here, we do have resources about data practices as well as the open meeting law. And additionally, we do have all of our the Commissioner's advisory opinions on the website and online for you to review. You can find more information about our webinars if you go up to News and Events, highlight Events, and then go to Webinars here. If you are experiencing audio issues during the webinar, you can select the Read the Audio FAQs link here, and that'll bring you to a page that will give you some FAQs and help you troubleshoot if you do have any audio issues. Also, we are recording this presentation, and you will be able to view the webinar later. We've also started posting the slides from our webinars, and you can find those right here on that page, the webinars page. To view our recordings, you can either click on the resources here, highlight training materials and select videos, or go all the way to the bottom of all of our pages and select the YouTube icon. So I'm going to click on that here. Okay, this is our YouTube page for the Data Practices Office. You can find all of our videos on the videos link here, or we do have some playlists from our previous webinars. You can find the Open Meeting Law webinar here, the Government Personnel Data webinar series, and then also the Law Enforcement Data webinar series right here. You can actually, we'll actually be posting the videos from today's webinar within the next day or so, and so you can find that there too. Okay, if you'd like to also download a copy of today's slide, I'm going to share a PowerPoint file with you right now to download the slides and save it to your computer. So just one second. Okay, well, I'll also share this file near the end of the webinar for those who join later or miss it this time around. A pop-up window will appear, and then you can choose to download and save it to your device, and so you should be seeing that right now. And I'll give you just a moment to do that. Okay, so turning to today's session, today's session is the final webinar in our series about law enforcement data that we've been presenting over the past several months. Today, we're going to highlight and briefly recap the law enforcement data webinar series, highlight some new law enforcement data provisions enacted during recent legislative sessions, and then also walk through some questions our office frequently receives about law enforcement data. We'll also have some time at the end for your questions, so please feel free to send them in. When sending questions, please send them to all panelists so we can be sure to see them. Okay, let's first take a couple of minutes to briefly recap what we've covered during this webinar series so far. Again, you can find recordings of all of these previous sessions on the Data Practices Office YouTube page. In the first session, we covered the basic requirements of the Data Practices Act, which is found in Chapter 13 of Minnesota statutes. As a reminder, government data is presumed to be public, which means most government data is available to anyone who asks for it, unless a state or federal law says otherwise. Minnesota statutes, section 13.82, classifies law enforcement data. We discussed how 13.82 distinguishes between active criminal investigative data, which is classified as confidential, and inactive criminal investigative data, which is typically public. However, some types of law enforcement data must always be disclosed regardless of the investigation status, including arrest data, request for service data, and response or incident data. We also highlighted identities that must be protected in law enforcement data, which are prescribed in 13.82, Subdivision 17. The second session of this series focused on the classifications of law enforcement video data. Specifically, we discussed that body camera data has its own statutory section, and classification depends on whether it is part of an active or inactive investigation. However, other types of video data created by law enforcement, including dash cam footage or weapon camera footage, are typically classified according to 13.82, or they would be presumptively public. Our third webinar highlighted several miscellaneous provisions of the Data Practices Act that law enforcement agencies should be familiar with. We discussed the classification of 911 calls, identities of individuals who submit property complaints, and law enforcement personnel data. We focused on limitations related to disclosing state accident reports, while also reviewing how law enforcement agencies should handle medical information. The fourth webinar covered requirements related to police officer records on children, which are governed according to Minnesota statutes, section 260B.171, subdivision 5. That section classifies most of this data as private, but there are some exceptions. We also discussed situations in which law enforcement are required or permitted to disclose data about children, and we walked through scenarios where traffic incident data included information about juveniles and how to handle those situations. As we pointed out during that webinar, law enforcement data about juveniles can be tricky because of the different statutes that get involved. So please don't hesitate to contact our office when you have questions about these types of issues. We're always happy to help walk through them with you. Next, we're going to highlight some changes to provisions governing law enforcement data made during recent legislative sessions. Okay, during the 2020 regular legislative session, the Minnesota legislature added a new statutory section governing law enforcement agencies' use of unmanned aerial vehicles, which are also known as drones, as well as the subsequent data that is collected, created, or maintained. The section classifies most drone data as private or non-public, with some exceptions, and importantly, drone data that are part of a criminal investigation are governed according to 13.82, subdivision 7. The section also places limits on the retention of data collected by drones, and law enforcement agencies must delete drone data as soon as possible or no later than 7 days after collection unless the data become part of an active investigation. Law enforcement agencies must also hold a public comment period before purchasing or using drones, and each agency must develop and post a public policy regarding its use of drones after soliciting public comment. During the second special legislative session, the state legislature also created and amended statutory sections regarding peace officer data. Specifically, data about individuals who receive peer counseling or critical incident stress management are private, with some exceptions. Additionally, the legislature created a new unit at the BCA to investigate incidents involving the use of force, and the BCA must post inactive investigative data from these investigations on its public website. The legislation also created requirements for local law enforcement agencies to submit public data related to misconduct investigations to the post board. The board itself is tasked with creating a database to collect and maintain this data, as well as specifying what types of public data should be submitted into that central repository. Okay, now we're going to turn to some frequently asked questions that our office receives. Question number 1, for data classification, when does criminal investigative data become inactive? After it becomes inactive, can the investigation become active once again? Just as a reminder, active criminal investigative data is classified as confidential except for the always public data defined in 13.82, subdivisions 2, 3, and 6. When a criminal investigation becomes inactive, the data become public with some exceptions. So to this specific question, Section 13.82, Subdivision 7, describes the situations when an investigation becomes inactive, which includes A, when a law enforcement agency or prosecutor decides not to pursue the case, B, a charge is not brought within the time frame set by a statute of limitations, or C, the defendant has gone through the court process and all appeals are exhausted or the time to appeal has expired. Although not described in statute, an investigation also becomes inactive when a defendant goes through the court process and is found not guilty or is otherwise exonerated. It is possible that an inactive investigation can become active once again. For example, a law enforcement agency may begin an investigation but determine that it doesn't have enough evidence to pursue the case further. So the investigation becomes inactive and most data become public. However, the agency may later learn more information months later and determine that it should reopen the investigation. As a result, the criminal investigation becomes active and the related data are confidential once again under 13.82 Subdivision 7. Now, there isn't a bright line rule about when an inactive investigation becomes active, so that determination would be left to the appropriate law enforcement or prosecutorial authorities in your area. Moving on to question 2. Can law enforcement agencies share not public data with other law enforcement agencies? Yes. Section 13.82, Subdivision 24, makes clear that law enforcement agencies may share not public data with one another so long as the exchange is, quote, pertinent and necessary to the requesting agency in initiating, furthering, or completing an investigation. End quote. The statute doesn't provide any further guidance on when sharing data is pertinent or necessary, so your agency will probably want to make sure it has processes, procedures, and policies in place to handle requests for not public data that come from other law enforcement agencies. A couple other things to note here. First, this section makes clear that law enforcement agencies are not permitted to share not public personnel data, and they cannot share data they maintain because someone is protected under the state's Safe at Home program. Second, this section does not require a law enforcement agency to share information upon receiving a request from another agency. Rather, the authority is permissive, meaning that your agency can determine whether sharing the data may be pertinent or necessary, and you can decide that you won't share data. Again, having policies and procedures in place before receiving a request from another agency can help you prepare to make a determination about whether to share data in these types of situations. Okay, question number 3. Our agency has medical information about a victim in one of our inactive criminal investigative files. Is the data about the victim's medical conditions public? This question is a tough one because, as I mentioned earlier, inactive criminal investigative data is usually public, and data related to medical conditions is often viewed as being pretty sensitive information. But in this situation, the data about a person's medical condition is probably public. Law enforcement agencies are not typically subject to the requirements of HIPAA, which means they do not need to follow that law's strict limitations on sharing medical information that an agency happens to maintain. As a result, most medical information that your department has collected during an investigation would be subject to the requirements of Section 13.82. However, there may be situations when your agency obtains health records directly from a medical provider. If that's the case, the Minnesota Health Records Act would prohibit any further disclosure without receiving informed consent from the subject of the records. For your reference, I've included the statutory citation on this slide where you can get more information about the access limitations created by the Minnesota Health Records Act. Okay, on to question 4. Our law enforcement agency received a 911 call from someone reporting a mental health emergency of another person. Whose identity is protected if we receive a data request for the call? This, again, is another difficult question that we often receive dealing with sensitive health information. Remember, the Data Practices Act does require law enforcement agencies to protect certain identities from being publicly disclosed. Specifically, Section 13.82 Subdivision 17F requires law enforcement agencies to withhold public access to data when it would reveal the identity of a person who placed a call to a 911 system, or the identity or the telephone number of a service subscriber whose phone is used to place a call to a 911 system. And the purpose of the call is to receive help in a mental health emergency. This language means that the caller is the person whose identity must be protected, which may not necessarily be the person with the emergency. For example, if the caller is experiencing the mental health emergency, then the identity of the person with the emergency is protected as required by Subdivision 17F. However, if a person calls 911 to report someone else having a mental health emergency, only the caller's identity is protected, and 13.82 Subdivision 17F does not protect the identity of the person who has the emergency. So in this situation for the question, only the caller's identity is protected even though she did not experience the emergency. Meanwhile, the identity of the person who experienced the mental health emergency is presumptively public unless a different provision of the Data Practices Act would classify the identity as not public. Okay, question 5. Can a law enforcement agency disclose confidential data if it would help solve an investigation? Yes, Minnesota Statutes Section 13.82, Subdivision 15, permits the disclosure of data classified as confidential under Subdivision 7, or data classified as protected non-public under Section 13.825, if disclosure would benefit the public in certain circumstances. Your agency would probably want to work with legal counsel to determine what types of situations may call for disclosing not public data as a benefit to the public, as well as having processes and procedures in place to help your agency make these types of decisions. Okay, question 6, and this is the last question that we have for the FAQ. Our law enforcement agency has juvenile law enforcement data about a data subject classified as private under Minnesota Statutes Section 260B.171, Subdivision 5, but the data subject is now an adult. Has the classification of the juvenile data about the subject changed? Can a parent have access to juvenile data when the subject is an adult? As I mentioned earlier, questions about juvenile data in the hands of law enforcement can be tricky, so definitely give us a call when you have these types of questions. But in this situation, no, the classification has not changed. The law enforcement data would retain its classification as private according to 260B.171 Subdivision 5 because the data subject was a juvenile when the data was created. The classification of this type of data does not change when the juvenile becomes an adult. However, any subsequent law enforcement data created about the data subject as an adult would be classified according to 13.82. Additionally, the parent would have access to the data while the subject is a juvenile because the Data Practices Act permits parental access to data about their children who are minors. However, parents lose that right of access when the child becomes an adult. In this situation, the parent would not be able to access juvenile law enforcement data classified as private about the adult child who is the data subject. Okay, so we still have some time for your questions. If you do have a question, please send it to all panelists in the Q&A panel. That way everybody on staff here can see it. But as you're submitting questions, we just want to mention another office at the Department of Administration, which is the State Demographic Center, who is leading the work on the 2020 census. We wanted to highlight this work because a good census is the foundation for a fair democracy. We know that you all want to be counted, and the folks you work with and serve want to be counted too. You can learn more about the census on the website listed on this slide. It's important that our state has a complete count because it will allow Minnesotans to be fully represented in Congress and get funding for needed services. So please, please, please fill out the census if you haven't done so already, and really encourage everybody in your community to do so also. All right, I'm going to put up the PowerPoint slides once again for you to download while we're taking questions in case you missed it the first time. The slides will also be available on our website in the next day or so. And as we're answering questions here, as you're sending them in, and you hear a silence or a pause, Don't worry, your audio is still probably working. We're just making sure that we're going to get to all questions and reviewing them so that we have answers for you. So definitely please send them in to all panelists in that Q&A panel.
All right, we're just waiting on some questions, so if you have any, please let us know. I just wanted to remind you as well that all of our webinars are on our YouTube page, which you saw earlier. And so if you want to revisit any of them or hear the question and answer sessions from those, they are on the YouTube channel, as this one will be in the next day or two. At this point, we don't really have any questions, so I'm just waiting to see if we have some, and then I will read them out here. So we received a question about that provision about protected identities under Subdivision 17 for mental health emergencies. And so the question is, for 911 calls under 17F for mental health, could the relationship between the caller and the person needing help allow for needing help be redacted? Example, if it's a spouse or a parent. So as we discussed in that first webinar about identities, identities is certainly more than a name or other a phone number. So to the extent that there is identifying information about the caller, then you can redact it. If you determine that that relationship would identify the caller, then yes, you can redact that under Subdivision 17. Another one related to mental health emergencies. I know these ones can be very uncomfortable for law enforcement because we don't have just sort of a general health or mental health classification for law enforcement data. The question is the subject of a 72-hour hold public from a 911 call? So again, if somebody is having a mental health emergency that you might require that 72-hour hold, the caller is protected, but the subject, to the extent that you have, that law enforcement has an incident report, a police report saying that they responded to that sort of incident, that identity would only be protected if somebody called for themselves. If the caller is someone else, you would protect the caller's information, and the subject of that hold might be made public then under your just general incident report. We don't have a specific question, but I'll just say generally that calls for welfare checks or calls that don't result in active criminal investigations, calls that are not criminal in nature, are just generally presumptively public. And this is where we get into situations where that might feel uncomfortable when it is sort of a welfare check or it might identify somebody. Generally, those are just going to be public. For a very, very few set of law enforcement calls or identities, law enforcement can consider where there is a safety concern. If there's a very serious safety concern that you can articulate, then you have security information 1337 to protect those situations. But again, that's going to be a pretty narrow set of circumstances. A question about security information and whether there's a test for that safety concern. There isn't. There's just the language in 1337. Law enforcement webinar, the third law enforcement webinar, we talked a little bit about security information and the language in there. But it has to, the disclosure has to be likely to result in a security a substantial jeopardy of the security of a person or things or information. So it has to be likely that if you disclose this information, substantial jeopardy would befall a person or things or information. So that is kind of the high bar that the legislature set, because basically it allows government to take presumptively public data and then just make it not public. And so again, it has to be likely to cause this safety concern. Oh, the person asking the question clarified that he was talking about the language in 1382 subdivision 17F, where we're talking about the caller for a mental health emergency. And it says that if there's a safety concern, then if the agency determines that revealing the identity may threaten the personal safety or property of any person, or the object of the call is to receive help. So those are two different provisions. There isn't a test for that. Again, I think it's if you have information as a law enforcement agency that would suggest that there is a threat to a person or their property, then you can make that determination. You just want to make sure that you document that. So that could be a request from the person. It could be information that you or law enforcement has uncovered in the course of responding to a call. You just want to make sure that you document that determination and, in order to provide the protection, again, to the person who placed the 911 call. All right, I'm not seeing any more questions, and we are at time, but thank you very much for joining us today to kind of talk about our wrap-up of our law enforcement series. Again, this is number 5, so you can always go back and take a look at 1 through 4, where we talk about various issues related to law enforcement. We are going to have a September webinar, so watch for notice of that. We are finalizing what we're going to talk about in that. If you have any ideas for us, please fill out the survey that will pop up when you close out of the session today. So thank you and take care, and we look forward to talking to you soon.